Welcome to the next Rookie Series webcast with TBA, sponsored by the Amazing Young Lawyers Division. Today's topic will be family law trends and challenges. Just some quick notes before we begin. Today, you can utilize the chat feature. So if you have any questions for our panelists as you go, feel free to put those in the chat. I will also be sending everybody some certification information following the presentation, so you can certify in your TBA account. And we're going to go ahead and get started. So I'm going to hand it over to Julie Chapman with the Bowers firm in Memphis. Thank you, Julie.
Thank you. Okay, hi everybody. Welcome to today's CLE. This CLE is part of the Rookie series, and we're talking about family law today and just getting kind of into the basics. So I have enjoyed serving on the TBA YLD board as the CLE chair for the West Memphis division. And the Rookie series is something that we've just put on to get to the basics of what we practice and get that out there for everyone to just kind of, if you have been practicing, look at it as a refresher, or if you're new, then learn some of the foundational knowledge that helps us in the practice. So we have a great panel today, and I'm going to let them introduce themselves. If you want to start, Lipa, that'd be great.
Sure. I am Libba Fike. I am a partner at Butler Severe Hinesley and Reed in Memphis and a former YLD board member. And I practice predominantly in family law, obviously, and I do a lot of guardian ad litem work. And I'm a professor at the University of Memphis, Cecil C. Humphrey School of Law, teaching a class on how to be a guardian ad litem.
Chelsea?
I am Chelsea Connor. I am a partner at Gill Family Law, also in Memphis area, Germantown. And I practice primarily in family law, divorce, custody, child support, terminations, adoptions, all the fun stuff.
Fantastic. And Will?
Hi, I am Will Ross. I am an attorney at Butler Severe Hinesley and Reed in Memphis. Like everybody else, I predominantly do family law, work with the divorce, child custody, all the dramatic things that we get to see.
So thank you guys so much for being here today. I appreciate all the knowledge that y'all have bestowed on me, and I'm looking forward to learning more from y'all during this panel. So let's get into it. Let's start with, how does practicing family law differ from the other areas of practice? If anyone wants to take it away.
I'll go first.
Yeah.
Because I actually, prior to going into with Gill Family Law, my current law firm, I did actually do some probate and just general civil litigation. And that was 2020 to 2023, I guess. And so the difference in those areas versus family law is I would say the creativity that family law is allowed. I mean, you can basically style a motion to do anything, and just kind of throw it against the wall and say, this is what I want, like to do an inventory of the home or to appear virtually for a deposition or just access to a bank account or to force someone to file an IRS power of attorney. And so you just kind of throw everything against the wall and be creative, and sometimes it works and sometimes it doesn't. So I think that's the main difference in family law versus other more, we have rules, but they can kind of be um, not bent, but worked with more is probably the better term.
I agree with that. I also think, just practically speaking, being a family law attorney is much more emotionally draining than other civil areas of the law, because we are dealing with people who are in the middle of a huge crisis. And I have to remind myself of that every time I have a new client, that I may do this every day, but this is a divorce, or somebody's trying to terminate their parental rights, or whatever it is. And having to, you take that on, and we become more of a counselor sometimes, even though we're not supposed to. We do, we are a sounding board for our clients. And so Emotionally speaking, it's hard to stop the clock at 5 p.m. when I go home because I still have these cases going around in my head because these are actual lives that we're impacting. So I think that's a difference, a big difference.
Well, I'll chime in for a moment. I don't have much to add either. I have only practiced in family law, so when it comes to um, differentiating family law from others, all I can go is based off of what my former classmates from law school have said and what they do. And it seems like often their workload may be very different from us, but it definitely, we have real hands-on interactions with our clients who are very much real people. Um, and so, and people can be frustrating, but people can also be really great. And so there's a part of it to where, we just have to deal with certain things as they come. Every day is different. I find if I have nothing on my calendar, those often become the most stressful days because then everybody apparently needs you at that point in time.
Yeah, for sure. I'm gonna direct this question more towards Chelsea and Libba, but will feel free to chime in for this one as well. But what are some of the biggest mistakes that you guys have seen newer attorneys make in family law? If you see something that is done a lot that probably we should stop doing.
I think overcompensation. You come out of law school. We all know we've all been there. We all know that you're a new attorney. Um, you don't know everything. I don't know everything, and I've been practicing for 13 years. And so, um, you learn from people, take a breath, take a beat. Um, and usually the mistakes that we make in this line of work, most of them can be fixed. And that was a big lesson that I learned um, early on. I'm not a physician, I'm not a surgeon. If I make a mistake, typically, right, nobody's gonna die. But there are mistakes, and you're going to make mistakes, and you just need to learn from them. But don't come in all guns a-blazing because you're going to get schooled by these attorneys who have been doing this for decades.
I think one of the things that I see is just not knowing the rules, whether it's the local rules or the rules of civil procedure, and I'm guilty of that. I have since gotten a mentor, but previously I did not have a mentor who told me to just start with the rules, start with the law. And so previously, and I'll call myself out, I went in front of the same judge for 3 different Fridays for a Friday motion docket and was wrong on the same thing for 3 weeks in a row because I wasn't looking at the rules. I wasn't following the rules. And so when I finally looked at it, I was like, oh, this is how you do it. So it's really just getting familiar with the rules and kind of what Liv was saying is just being humble because I was always taught you really don't want to be the smartest one in the room. So learning from other people, walking up to people like, oh, I saw you argue this motion. Like, you want to go have coffee and just get to know people that practice in your same area that can kind of guide you so you don't make those mistakes.
Yeah, one of the things that I had to learn kind of early on that I'm still working on is just learning how to manage client expectations. And sometimes I feel like as humans, we want to tell people what they want to hear, but our job as their attorneys and their litigants is to, or their advocates and the people that litigate for them is to level with them and, maybe tell them that they don't have the best position and maybe tell them things that they're not wanting to hear because the last thing that we should do is make expectations exist that aren't reasonable because that's just going to cause problems later on. So I've definitely learned to manage expectations and have clear communication from the beginning. And that's something that I have to be mindful of because I think it's easy to want to be like, oh, well, maybe we can do this, maybe we can do that. But I think you also need to tell them what's likely and what the law is probably going to say for sure. Chelsea, we've talked about this a little bit. You mentioned mentorship as well. What do you think the importance is of having a mentor and just being able to ask someone questions and have, someone that you can really be honest with when things are getting a little dark?
Yeah, I think it's really important. Like I said, I didn't come from somewhere previously from where I am now with a true mentor. And so seeing the difference of being able to ask questions so that you learn, so that you're not going into court and making some of the mistakes that maybe your mentor made. Um, and knowing that your office or, the coffee shop that you go to with an older attorney is really a safe space and a place to bounce off ideas with someone. Also get mentors in other practice areas, especially in family law. We have a case now that we're arguing shareholders' rights for a corporation. And as a family law attorney, that's not my area of expertise, but we're making those arguments, and we wouldn't have known to make those arguments had we not had outside people. So getting people that you're not just funneling into just family law, getting to know other attorneys that are older and that have been practicing for a while. And I mean, some younger people can teach you things too that, we kind of get in, oh, the rules have always been this way. The law has always been this way. Maybe it changed.
So let's start talking about a little bit of family law and the foundations of that. So if you guys were in a consultation with a new client that was getting more information on a divorce and considering that, what are some of the main things that you would discuss with that potential client?
Um, I mean, number one, we need to know, are there kids? Um, you know, when I have a new consult come in, I say, all right, what's going on? Tell me what's going on. And they always say, well, where do I start? And I say, well, let's get the facts first. How long have you been married? Do you have kids? What does your marital estate look like? Do you have a house? Do you have 401ks? What kind of debts do you have? And it's really, it's very important, again, that you remember that this is an emotional time for these clients, but you have to rein them in so that we get to the legal part and we're able to adequately advise them on next steps. And so, you know, I always start with, when were you married? And then once we get through the factual information, talking about, all right, why did this happen? Because the why is always important. And that's something that I try to instill in my students at the law school, but you always need to get to the why, and try to understand, was there adultery? Is there substance abuse? Um, we've had a lot of clients come in and they appear very well educated, well spoken, but in all actuality, there are some extreme mental health issues that we don't realize until later. And if I had just done a little more questioning to find out their history, and I probably would have caught on to that a little bit sooner. But starting with the facts for me is what I do, and then I get into the more emotional aspect and try to understand why my client or why the potential client is in my office.
That was great. Well, Chelsea, did y'all have anything else that you kind of always try to do with initial consults?
I'll say that sat on or sat in a ton of Liva's consults, but as I've started to take some or consults on by myself, I like to ask what is their relationship like now. Obviously, they're legally still married, but can they communicate? Because if they're able to communicate and have a good conversation, not only is the process generally a little bit smoother, it's also a lot cheaper for them too. And that's a big selling point on that end of things because it adds up really fast, especially when you have a client who's constantly emailing you or constantly calling you and you're responding and you're talking to them all day. It adds up really fast. And so I know that anytime you can kind of sell something as, I'm trying to help you out money wise, I'm trying to be a good steward of the money that you're entrusting me with, that I think that kind of goes a long way.
And always ask, what's the worst thing the other party is going to say about you? that's what, all right, tell me what's the worst thing that they're going to do, or what's the worst thing that they're going to say or that you've done. So yeah, I always ask that question too.
We do also the same thing, information gathering and then getting into the more emotional things. One of the questions we also ask is, are you having an affair? Because if you are, stop. Um, or if we know that there's going to be alcohol or drug allegations, can you pass an alcohol test? Can you pass a drug test right now? If the answer is yes, you need to go to Mid-South drug testing now, because if we know that's going to come up later. And then also, if you have what we would call the out spouse who really doesn't know anything about finances because and it could be the husband or the wife, and they don't know anything because they've just been so hands off. You know that you have to start issuing subpoenas. Have they seen one bank statement? Or where is that person employed? And then we can pull the bank statements from there and issue subpoenas to that. Or do you need emergency relief? Like, do you need an order of protection? Or do you want to try to get them out of the house? And also, as Julie said, managing expectations, because that emergency relief, it gets expensive quickly. And so explaining that to them, that it's a lot of drafting and then going into court and expecting to have a hearing quickly. So just managing those expectations. So what do we have to do for next steps? Can it just be I mean, most divorces are not simple, but is it going to be a more simple divorce, or are we going to have to come in guns blazing because of some allegations?
Yeah, it sounds kind of simple when we just discuss it. Like, were you married? Were you divorced? But we all know that by the time people get in for a consultation with us, there's normally been a lot of emotions, even getting into the seat for the consultation. And so they normally have either a lot to share or they're processing in like a really emotional way. And so it's a lot of like wrangling of emotions, trying to get the necessary information and spend your hour or hour and a half as efficiently as possible. So I enjoy initial consultations and I'm looking forward to taking more of those, but they're a little nerve-wracking when you're starting to practice and you're getting your skin in the game and meeting with a client and you don't really have much courtroom experience yet. And so, how would you guys advise a new attorney to discuss the property valuation and property disputes if they're in a consult as well?
I think it starts from that initial consult and gathering the information. Gather as much information so that you can be knowledgeable. And we start basically from the very beginning drafting what's called a marital balance sheet, which is listing of assets, debts, other assets, like does someone own an ownership in a business entity? What kind of entity is it? Is it an LLC? Is it a corporation? We need the formation documents and things like that. And is that going to be valued? So just gathering all of the information, which again starts in the initial consult, I would say.
And I think a misconception is a lot of people think like, oh, I had this bank account in my name, so it's my separate property during the marriage. We get that all the time. Like, oh no, I put my paycheck in my bank account, so it's separate. And you have to be kind of the one to be like, that is not how it works. Um, okay, great, guys. So what factors, we're going to move on to alimony and spousal support. What factors do courts weigh most heavily in alimony decisions?
Well, this is like, the number one question that we get when, what's going to happen. There's four types of alimony, but the two biggest things that the court's going to look at is the one spouse's need and the other spouse's ability to pay. And trying to make sure that post divorce, those parties are living a similar standard of lifestyle, either that they enjoyed before the divorce or that they are similarly going to have post divorce, because we don't want to put one spouse out on the street and the other one is, living high on the hog. And so there are a myriad of factors that the court will take into consideration: the length of marriage, the education of the parties, the employment history of the parties, but those two biggest factors are going to be the one spouse, the disadvantaged spouse's need and the ability to pay by the more advantaged spouse.
Yeah, I've noticed with alimony now that I've started kind of doing mediations on my own as a new attorney, alimony seems to be one of the hardest things to advise a client on because it's not like formulaic like child support. Alimony is something that's a little bit more flexible and very, like you said, LIBA dependent on a lot of different factors. There's some main things that we consider, but it's like juggling how the duration of the alimony is and then the pay as well.
It's
Um,
also kind of what you're talking about, Julie. It's very hard because there's no magic formula. Some states have like a guideline, and if you've married this long, we're going to be in this category. Tennessee doesn't have that. And so, how do you negotiate future alimony to make sure your client or trying to argue against future alimony for the other party? But it's more that's prospective because it's like, what are they going to earn in a few years? So that's hard and not easy to conceptualize planning for the future.
And just make sure you understand the differences between the different types of alimony. Um, we may not have a magic formula, but I do appreciate the the way that we can be creative when it comes to alimony and what we call it. Um, and sometimes we call, attorney fees, we'll call it alimony, so it doesn't make one of the other spouses mad. I'm never going to pay them attorney fees, but we call it alimony or something, and that makes them feel better about themselves. I don't know, but just understanding the differences because that does affect your clients in the future, whether they can modify it down the road. At what age does it stop? Does it stop? And can they cohabitate with a third party or there are so many different ways you can make it work. So I do appreciate that part of the way that Tennessee looks at alimony.
Yeah, absolutely. And we always have, I think, the people that are like, well, they had an affair. How are you gonna include this affair in this divorce? Because, but it's not fair that they cheated on me, so they need to be punished by the law. And how would you advise a client about that?
I'm very upfront and frank with them. It's like, I hear you, but it's like, I mean, it's one factor to consider in an overall set of factors, but the court isn't really going to be like, I'm going to financially punish you. But with that being said, you can add up any of these dates and these trips and make a claim for dissipation, and get paid that way.
Have you guys had any success in the past if you're at a divorce trial and you're talking about an affair at length? Like, have you seen that that has had a high impact on the judge when you're discussing an affair? I know it's kind of different between judges, but you know.
I mean, I think, yeah, it depends, I think, on the severity, right, of the sin or whatever you want to call it. But some of these judges in Shelby County, we have judges that are ministers, on the weekends and so they are definitely going to look at adultery or affairs as something different than another judge. But I do think when it comes to the type of affair, is it emotional affair? Has there been a physical affair? Has the adulterer exposed many minor children to this person? I know we try to keep alimony and child support separate, but it's hard to keep that separate when you get into the muddy waters of emotions. But I always remind my clients that just because someone had an affair does not make them a bad parent. It makes them a bad spouse, no doubt, but it doesn't make them a bad parent. And so it's hard for people to understand a lot of times that while it does affect alimony or it can affect alimony, it's not necessarily going to affect a parenting plan or child support.
Yeah. Okay. Next question. What are some practical strategies? Oh, we already did this. Never mind. I was going to say that help in negotiating spousal support, but we've kind of already gotten that gotten that done already, guys. So let's move on now to parenting plans and child support, kind of like what you mentioned, Liba. What best interest factors tend to come up and matter more or most in contested custody cases? What are we looking at a lot of the times? If y'all have any, or just in general.
I would say just
No, I was going to say Will needs to answer.
okay. I would say I don't know if this would be like one of the best interest factors. It definitely plays a role into it, but a lot of the times, when going through the parenting plans, we have big issues of where the child is going to school. Whether that's at a private school and either dad or mom no longer wants to pay for that private school for whatever reason, whether that's based off of where that primary residential parent is going to be living in the school district that they're in. Private school tuition, though, is probably one of the more difficult things to work with, and um, having to try and be as creative as possible when it comes to an offer of settlement, how that is kind of can play a role into it. We often see the parent um, who isn't really paying the majority of the private school tuition wants their child to continue going to that private school. That's a difficult spot to be in, especially if their spouse or soon to be former spouse is going to be paying child support, is going to be paying alimony, is going to be doing all these things. Those arguments are there on the other side. But a lot of the times too, that party can still pay for it, just as if they had been, living normally, during the divorce or pre-divorce process. So,
And I know a lot of times people will come in and say, if I have a stay-at-home mom, right, I should have the majority of the parenting time because I've been their primary caretaker. That is true. You have been their primary caretaker, but now there's a change. And you're not going to be living with your spouse. And so, um, you know, maybe you had an agreement with your spouse that you were going to stay at home and they were going to work. And so just by the very nature of that, you are going to be around the children more. And so, but again, that doesn't make the other person a bad parent. It just means that they're going to have to start stepping up and making changes to their lives, just like you're going to have to make a change to your life. And maybe you have to go back to work or whatever. But, we are seeing more and more, in my experience anyway, in Shelby County, we are seeing more and more of the judges really starting at 50-50 and then moving one way or another based on the specific circumstances. For many, many, many years, there was the weekend dad, right? That was what you got every other weekend and holidays and a couple weeks in the summer. And that's just not the case anymore. And parents, moms and dads are both, they both want to have a relationship with their children, and courts really are honoring that and saying, okay, I understand the history, but now there's a change. And so we have to give everybody a chance to prove that they can be a parent. And if the parent can't parent, then you change it in the future. But unless they're a danger to that child, you're generally going to need to tell your client that they need to resolve to the fact that they're not going to see that child every day.
Yeah.
That's exactly what I was going to say, was what Libba said, is trying to, reason or explain to clients that I hear you, that you've been the primary parent forever and ever and ever, and this person doesn't do anything except hopefully financially support the household, sometimes not. And explain to them like it's just not going to work that way in the future. But In the future, you will have a docket number. And if there is an emergency, you have access to the courts. But they still don't sometimes get that because it is their baby and their child.
Yeah, we've had a few instances recently as well where, you know, it was like it until something, they had a certain schedule till the litigation began, and then they're like, well, Judge, he never saw him, and the judge is like, I don't care about any of that. What I care about is going forward, how available each parent is to see the child, and a preference to do 50-50 if at all possible, for sure. And the best interest factors are something that we all have to become very familiar with because we deal with them every day. And oftentimes, that's one of, at least what I've seen, one of the main issues that we discuss on appeal as well is going through all of the best interest factors as well. And when there's issues with the parenting plan, obviously. So that's something that I've become really familiar with recently too, is going through all the best interest factors. And there's even more now. So that's great. Even
And
more things.
also, what Liv was saying is that if they're a danger to the child, sometimes there are emotional abuse allegations from one parent to the other, and the long-term effects of that. And if there is, get an expert witness as soon as you can, because emotional abuse is the hardest thing to prove to a court because you can bring in pictures of bruises and scratches, but you can't bring in pictures of emotional abuse and stuff like that. So leave that more to the professionals.
Absolutely. And we've seen a trend in the courts recognizing that that exists now, but it's really hard to establish what that looks like, for sure. Um, this wasn't something that I had listed, but I think that is kind of it's easily related to this, but talking about the child's preference, and I feel like you have a lot of experience with this, Liba, as a guardian ad litem, and also just your interaction with children in general. But a lot of parents also are like, my child's 13 years old, they should be able to say that they want to live with me, and a lot of people believe that their child's preference is heavily weighed by the court. Do you want to talk a little bit about the child's preference and what that looks like?
Sure. So in Tennessee, per our statute and the best interest factors, the preference of the child may be considered. If the child is 12 or is under the age of 12, a child's preference shall be considered by the court if the child is 12 or older. But again, that is one of just, a, a like Julie said, a very large number of factors that the court has to weigh. I also get parents who will say, "Well, my child wants to testify, and my child wants to go and speak to the judge in chambers." And when I'm in a guardian position, I say, "Okay, I understand." But that is so traumatic for a child to go into a courtroom and have to sit in front of an adult in a black robe and attorneys and everything else, a court reporter. My job as a guardian ad litem in custody disputes per Rule 40A of the Supreme Court rules. I can tell the court, I can put on proof to the court of what the child's preference is. I can also put on proof as to what I believe is in the child's best interest. Those are two very different things. And so I don't see a necessity in having a child testify, especially if there's a guardian ad litem, because the court can know what the child's preference is without having to put that child through that experience. But also, what I have to tell my clients and remind them is that these children are caught right directly in the middle, and they're going to tell one parent one thing and they're going to tell the other parent another thing because they don't want to be the one that makes this all fall apart, and they don't need to be the one that makes the decision, right? That's what the adults are there for, and that's why the judge is there. And so I there are numerous ways that you can get a child's preference in to the court without the court having to hear from the children directly, although sometimes it is necessary and sometimes courts request it. Um, and that's fine. But I just, especially when there's a guardian ad litem involved, I just don't think it's necessary for a child to testify. But I do think that courts are putting a little bit more emphasis on a child's preference than they used to. Again, it's not the end all be all. It's not a final decision making factor, but it definitely is taken into consideration and weighed. There's more consideration given to it than now than I think that there was in the past.
And I've been on actually both sides of the argument. One, I wanted the child to testify because she was 15 and the dad wasn't seeing her at all. And the court actually, and the child was in the courthouse, and the court actually refused to hear from her, but did make the dad and the daughter hug in the courtroom, which was interesting. Um, but then I also don't like getting kids involved. Because again, it's one of 17 factors that a court looks at. And so usually my typical request is that the court hears all the proof and then the court determines if they want to hear from the child. Because like Lipa said, you're putting that child directly in the middle of their parents. And it's just an awkward position for a child to be in.
Yeah, I certainly wouldn't want to be in that position. I think that that would be awful. And we always talk to our clients too about like, kind of like what y'all both mentioned, your child's telling you this, but yeah, they're probably not going to say that anyway. Like they're probably not. They'll either say something completely opposite or not at all, or like you never know what any witness is going to say, but especially a child that's in the middle of this awful situation that no one would want to be in, and they're so little. Even if they're 15 or 16 or 17, that's still so young in the grand scheme of life to be involved in like a contentious divorce. Um, Obviously, that's my opinion, but I can see why it's also important too. And we've been on that side as well.
And it is
Um,
different with, juvenile court matters. Um, the courts in Shelby County, at least, the juvenile court is going to want a child to testify, especially if there are abuse allegations. And, I've seen very, very young children get in front of a court and have to testify as to what they've experienced. But that is a different rule that governs, the care of children and how they interact with the court. And so, but always have a good counselor on standby for these children. So.
And also be cautious of that they are a child. We had a case in Mississippi, um, in DeSoto County, and the child came in and told us about all these allegations, these sexual abuse allegations at the hands of her stepdad. So we jumped through all of these hoops to get her away from him. And then about 6 or 7 months into the litigation, she recanted everything and now no longer has a relationship with our client because she was like, I didn't actually say that. I didn't mean that. So they can go down to completely different avenues just like that.
yeah. And when you mention making sure that you have a counselor on standby, I think that that's good for family law in general. Asking your client if they have a therapist is something that I feel like we all do a lot, make sure that everybody's getting the emotional help that they need so that way we can advise them on the law. Because we do end up being therapists a lot, but it's great to also have your client have a counselor or therapist.
And
Okay.
it's good for you to have a counselor or a therapist.
It's good for everyone. Everybody
So
benefits.
is it? Maybe
I
I
mean,
need to
it's good.
Google.
I'm like, my counselor is on standby at all times. So,
Well, and that's an important point to bring up too, Liva, is, people that practice in the legal profession in general, and especially family law, I think, are struggling with handling all of this and the intensity of which our practice is and how it affects people's lives directly. And so it's important to be taking care of yourself in whatever way that you take care of yourself, but being mindful of what you need and taking breaks and resting and getting help for yourself as well.
Julie, there's
So,
also a question in the chat.
ooh, great. Let's see if I can figure out how to see it.
Says how
Okay.
to deal with situations where your client or the children need a resource that they cannot afford, whether it be a GAL or a counselor.
That's a great question, Nicole.
There are definitely services, you know, in and around Tennessee. Guardians in juvenile court cases are appointed by the state and paid, they get paid through the state. I in circuit and chancery and non-juvenile court cases here, some guardians will do it for a lower rate. They'll do it pro bono. They can also be appointed by the state, and there are definitely certain types of cases that there has to be a guardian ad litem, like a termination and an adoption. The guardian ad litem has to be appointed, and if neither party can afford a guardian, then the court will appoint one, and that guardian can be paid by the state. Counselors are the same. There are several counselors that do sliding scales. So if you have a lower income, they will charge less based just solely upon your income. And there are other community-wide resources like the Church Health Center here, I know offers some sort of free counseling services and things like that. So there are resources out there to help families. There are not enough resources out there, but there are resources out there for families, and it's important that you familiarize yourself with those so that you can help clients, or if you're a guardian ad litem or if you're appointed as an attorney for a party, you can point them in that direction.
Right. Absolutely. Yeah. Okay. So, Will, got a question for you. How detailed do you think that a parenting plan should be?
That's hard.
That's a loaded
Depends.
question. I think the law school answer, and I think Chelsea might have just said it, is that it depends. But it really does depend on who your client is and who the opposing party is. If I tend to think just based off of a couple, well, I guess a few years now of experience that the less detailed often the better, because it's a little bit easier to follow. Sometimes it's really easy for people to fall into some sort of confusion based off of too many points that you're making. And another part of it is too, if you have a parenting plan that's so overloaded, it's not necessarily going to create the best relationship after this is over between the parents. From what I've seen, it seems to me that whenever we're modifying parenting plans, we get some that are come back that are really detailed, which can be really helpful. So it helps us knowing what needs to be enforced by the court, what needs to be changed by the court specifically, what is the other party not doing? Absolutely. But it definitely leads to conflict between the two parties. I think you can't think about it just during the divorce process. You want to try your best to get, and it's not obviously going to be perfect. Like half of our work is post-divorce issues, but you try to set them up in the best way possible so that way they don't have to come back to you. And oftentimes you might like a client and you'd be okay with them coming back to you, but other times that might not be the case. And so you want to be able to set them up and their families up for success. So again, the unfortunate answer is that it kind of depends, but sometimes it is absolutely necessary, especially if a party is struggling most with like substance abuse issues, or if they have a mental health history that needs to be addressed. then yeah, there's going to be certain provisions that need to be in there. They need to be very detailed about, breathalyzer testing, F testing, drug testing, all that stuff. That should be in there for sure. But um, outside of the really big issues that you might come to mind easily, sometimes I think the more limited, the better.
Yeah. And I like to remind my clients that the parenting plan is plan B. Courts and attorneys want the parties to co-parent effectively, and you don't have to use the parenting plan. If you can agree that you're just gonna, follow this schedule, you can put that parenting plan in a drawer and never look at it again. But it's there for when you can't get along. But it's supposed to be a backup plan, and courts want you to try to co-parent effectively because that is definitely in the best interest of the child.
The most other provisions that I have seen, and honestly, our office did the parenting plan, was like 38 different provisions, and number 38 was detailed into like 10 subsections. And we're currently in a post-divorce modification trial. Some of that, though, does have to do with special needs kids. So if you do have special needs kids, those need to be specifically detailed. This case, the one child has spina bifida, autism, esotropia, what it had to do with his eyes, and he has to do physical therapy all the time, wears glasses. So those specific things need to be very detailed in there because that can affect that child long term. If he doesn't do that, he can regress, have surgeries. So those things need to be detailed, but when you get to like, the 38 different provisions, it gets a lot. She did start with like 54 proposed provisions, so we did work backwards from there. But the 38 is a lot.
Yeah, I agree with that. Yeah, and also, and y'all correct me if I'm wrong, but this is still subject, the parenting plan is still subject to the approval of the court. And so your clients can decide something and y'all can work through it in a settlement discussion, and then you can bring it and present it to the court, and the judge can say, no, go back in the hallway and try to figure this out because I'm not signing that. So I think that's
Last week. So
it's something I didn't know was possible until it happened, and I was like, can they do that? And then it's like, oh my gosh. I thought if they agreed,
I worked so hard on this agreement. You just have to sign it.
right. But it's still subject to the court's approval. And so hopefully, I mean, and that doesn't happen often, right? But occasionally it does. Um I think Nathan might be one of your students, Liva, maybe?
he is one of my students.
Student shout out for Liva. Yay. Oh, I read the rest of that. Yeah.
Yeah.
It says it. That's awesome. And I know that I was one of Liva's students and I loved her class, so she's a great professor if anybody's thinking about taking it on the Zoom. Okay, cool.
I can second that.
Yeah.
Sorry,
I'll chime in since she's just down the hallway from me.
I had Liv as a guardian in a case, and she did a great job.
Yes. So let's talk a little bit. We're kind of getting close to the end here. Let's talk about trial skills. How do you prepare a client as to the best of your abilities when they're about to give testimony in court?
Repetition, preparation, repetition, repetition, repetition. You can go over the same thing 13 different times, and they may say something completely different that you've never even heard in court. But we treat any trial prep meeting with a client as if we're in court. So we have the exhibits so that they can see them, they can flip through them, they can feel them, and we go through their line of questioning. But again, you can do it a lot, and they may just say something completely off the wall that you've never heard, and you just kind of have to pivot. So their preparation, thorough preparation and repetition.
I'm
One
not
thing
good
that
at I'm awful at draw from. So I'll let somebody else answer.
That's what we do.
one thing that we've had our clients start doing recently, oh, Patrick just said, someone once told me as a law student that family law is the quickest way to get into court as a new attorney and get trial practice. Would y'all say that's accurate? Yes.
Yes.
Definitely motion practice. Like I will tell my students, if you ever have the opportunity, go to Shelby County Circuit or Chancery on a Friday and just sit and listen. Most of those cases are going to be family law cases because we are in court a lot. But we're usually there on these, like Chelsea said, these kind of like made up motions. And so, but yeah, just go and sit, and it's very interesting, and no two are the same, and it can be very entertaining.
Yeah, I will say compared to a lot of my peers that have gone into different areas of practice, I've noticed that I'm in the courtroom a little bit more than I would have been if I was at a different firm. Sure. And I think a lot of family law attorneys too just kind of get like the newer attorneys, they're like, go down to court and have fun. And then we just do. It's really enjoyable. I love family law. One
I'll
thing I was going
add
to
one thing. That's okay, Julie. Um,
please.
we have a lot of times we get clients ready for trial and then they end up settling, and that's definitely a good thing. I think what's something to stress is how much people risk by going to trial. There's a part of the when you go and have an uncontested divorce hearing, at least in Shelby County, one of the questions you have to ask your client is, do you understand that you could have received more or you could have received less from going to trial? And that's definitely one of the biggest risks that people, face, especially with parenting time. If one mom or a dad is so convinced that they need to have the most time possible, then there's a good chance that they need to capitalize on the most time possible that's been offered from the other side. Because it might just be go down back to 50-50 or less than that, depending on any sort of evidence that comes up preparing for trial.
Yeah, absolutely. I think stressing the autonomy that you have in your decisions outside of trial is something that is incredibly valuable to do with clients. Another thing that I was going to say that we've started doing that's helped our clients in trial a lot is, and this just kind of happened by coincidence, but we were doing a conservatorship for a special needs child that had turned 18 and was an adult, and his mother needed to, it was contested, and his mother needed to take the stand, and it was just highly emotional. And she had just been really anxious leading up to the trial. And we asked her if she had any like small toy or caricature or whatever that she could hold that would ground her and remind her of why she was doing it and for her child. And she brought like a little Woody doll from Toy Story. And it was like really small, and she just held it the whole time, and it really helped ground her. And since then, we've had a few clients where like specific bracelets that they've made with their grandchild, or bring a little rubber ducky, or like once we just mentioned the idea of having um a little
Emotional
thing.
support.
Yeah, like a little emotional support little thing that you can just kind of keep in your hand. Once we've kind of floated that idea, it seemed like almost everyone has had like, oh, I know exactly what I could bring, and that would really help me. And they hadn't thought about it or thought that they were able to bring something to court because a lot of them haven't been to court before. And so it's their first time, and you're like, no, actually, like it's totally okay, unless it's probably a big thing, and then maybe don't. But that's helped our clients a lot, for sure. Okay. Let's see. All right. How do young attorneys build credibility with the judges? And that's a big one, right? That's what we're all looking for.
Things
Always
being
mention your name.
prepared. Oh,
Yeah.
yeah.
Always, like that first year of practice, just remind the judge who you are, because they don't ever, I mean, they see hundreds of us a week. So it's, But I always say, live a fight your honor, Butler, Severe, Heinsley, and Reed. I don't know how many times I said that the first year, and once you're in good with one of them, they typically talk to each other and they will spread the good news about how wonderful you are. So,
And
Is
being
that what you
prepared.
think, Chelsea?
Well, that's a
Sorry.
good one too, and just being prepared. I mean, I still have to like when I go out to Fayette and Tipton County, I still show my bar card to go in there, and just introduce myself. No matter how many times I've been out there to Chancery Court, Juvenile Court, I'm making my way better, but Chancery Court, I still have to introduce myself because I'm just not out there a lot. Shelby County is a little bit different, but I think yeah, getting to know them, and also. They are the ones making the decision and they are in the black robe, but just remembering they're also human too. If if they're not wearing a dress, they put their pants on one leg at a time, just like you do. Like they're just human people. So try not to be as intimidated by them.
Yeah. Yeah, and like what you're saying with always be prepared, something that's important to know is you're just because you're going to get a hearing date doesn't mean that all you're going to need to talk about is dates when you're down there. Because a lot of judges are like, tell me what's going on. And as a new attorney, if you're like, I'm just here to get a hearing date, that's a way to build some credibility and say, here's what's going on, Your Honor, and and this is my name. So that's something. At first, I would just go down and bring the date, and then I realized very quickly that there was a better way to do that for sure.
A status conference is never really just a status conference.
Right. Something's gonna happen. Okay, so we have about 4 more minutes. And so if anybody has any questions that they want to submit in the chat, we welcome those. And if not, I know, Libba, we talked about the current bill in the legislature. If you want to give that a quick little spiel for everyone, and then if we have questions, we can handle those as well.
sure. I don't know the status of this bill, but I know that it's being discussed. That in cases where family law cases where there's a guardian ad litem appointed, the court would automatically appoint a psychiatrist, psychologist, counselor, someone to do kind of like an automatic evaluation or analysis of the child and the family and kind of provide recommendations. And the guardian ad litem has to say, well, this is why I don't think that the recommendations are correct. Um, I see a lot of good from that bill, but I also see a lot of pitfalls, and one being affordability. And, the counselors that we want, the psychologists that we want, aren't doing pro bono cases, right? You truly in family law across the board, lawyers, counselors, you get what you pay for, and so I think with some tweaks, maybe that could work out in the end. I have had all kinds of ideas about how to better a child's understanding of a guardian ad litem and the psychologists and counselors that are involved, especially if there's evaluations. But it's very interesting, and that's also a good point, Julie. Like, look and see what's going on with the legislature and see, because it's going to affect your practice. A few years ago, the adoption law, I mean, completely changed, and tons of factors were changed to make them more child centered instead of parent centered. And so, um, the relocation statute changed recently, and people are still going off of the old relocation statute. So just be aware of what's going on in the legislature and when these laws change, because they change often, and you never know what's going on.
Yeah, it's changed a few times since I've begun practicing, which was incredibly recent. So I can't imagine being someone who's been practicing for a very long time and still having to, like trying to unlearn things that you've been practicing because people change and our society changes, then the law changes as a result. And I know that they try to keep things as relevant as possible with the recent AB rules law, working on Abrams bill or Abrams law. I can't remember what's I guess it's the same thing. I don't know. But that was just,
There was another one that regarding the best interest factors if a child is wanting to transition or identify as a different gender than what they were born as, that if a parent does not honor that, does not use their pronouns, that cannot be considered emotional abuse or neglect. That's also something that's being discussed. So it's very niche. Both of those bills are very niche, and they affect my work, but family law is always changing.
and how would you recommend, like, what resources would you recommend for a new attorney to keep up with all these changes?
Chat GPT. No, I'm just kidding. I use Chat GPT a lot. I mean, Westlaw, the TBA email that we get every day that has new Court of Appeals opinions, Supreme Court opinions. That's where I learn a lot is when we look at these opinions and then we're like, oh my gosh, I can't believe that the Court of Appeals upheld this or changed this. But the TBA is really good, and I'm not just, sucking up, but the TBA is really good at informing its members of the changes that are going on with the law, with the community, just with everything.
Yeah. All right. Well, I think if there's no questions, I think we are done with the panel.
Well,
Thank
thank
you.
you. Oh, go ahead, Julie.
Thank you to all of the amazing panelists to take time from your day to speak with us and kind of share all of your awesome knowledge with all the family law attorneys.
Yes, we
for having us.
appreciate you. Thank you. For the attendees, again, I'll be sending certification information to you. Also, we have a new program sponsored by the Wild D. It will be in person in Nashville. It's a transactional program called the Business College. So check that out on our website. We also have several great rookie series programs on our website on demand that you can watch anytime. And we are rerunning some of those actually this month. So you can catch them on replays or on demand, whatever works best for you. So thank you again to our panelists. Thank you to Julie, Chelsea, William, and Elizabeth or Libba. We really appreciate your expertise on this topic. And everybody have a great afternoon.